But perhaps most of all, what these cases reflect is how much the Supreme Court's decisions affect all of us. I always encourage my students to think of cases not just in terms of their doctrinal significance, but with regard to their effects on people's lives. Because of Oberthal versus Hodges, same-sex couples now can marry in all 50 states and all territories of the United States. Because of King versus Burwell, between 6.5 and 10 million people will continue to have health insurance that otherwise they would do without. Think of the lives saved, the suffering prevented. These cases really do show us how much the Supreme Court's decisions affect all of us, often the most important, the most intimate aspects of our lives. So that's the immediate past. Let me talk about the present in the Supreme Court. There have already been a couple of decisions that are certainly important for those of you who practice or judge in the criminal law arena. One comes from Florida, and that's, of course, Hurst versus Florida, where the Supreme Court declared unconstitutional the Florida scheme with regard to determining whether the death penalty is appropriate. In Ring versus Arizona in 2002, the Supreme Court held that it has to be the jury, not the judge, who finds the circumstances we warrant the death penalty. In Florida, the jury just played an advisory role. The Supreme Court declared that unconstitutional. So as we were standing downstairs, a few people came up to me and asked questions like, will Hurst versus Florida apply retroactively? Well, here, got to keep in mind that the court said that Ring versus Arizona didn't apply retroactively. Will the court take a different view with regard to Hurst? What about criminal defendants who might not have objected at the time? Can they now raise the objection, or is there a procedural default? Here the question is there a way, sine habeas, to overcome the procedural default? Another case with regard to criminal law from this term came down on Monday of this week, Montgomery versus Louisiana, which is about retroactivity and will be relevant when you argue about whether Hurst applies retroactively. In Miller versus Alabama, the Supreme Court said it's cruel and unusual punishment to have a mandatory sentence of life in prison for homicides committed by juveniles. Does that apply retroactively? The Supreme Court Monday, 6-3, said yes. Justice Kennedy, writing for the court, he said this is a substantive change in the law, not just a procedural change. Substantive changes presumptively apply retroactively. There are so many potential blockbusters on the docket for this term. There's Fisher versus University of Texas at Austin, which was argued on Wednesday, December 9th. Can colleges and universities continue to engage in affirmative action to benefit minorities and enhance diversity? If so, what do they have to prove in order to establish that no race-neutral alternative can achieve diversity? There's Friedrichs versus California Teachers Association. It was argued on Monday, January 11th. Does it violate the First Amendment to require that non-union members pay the share of the union dues that go to support collective bargaining? In Abood versus Detroit Board of Education in 1977, the Supreme Court held no one can be forced to join a union, but non-union members benefit from collective bargaining. They benefit in their wages, their hours, their working conditions. Should they have to pay the percentage of dues that support collective bargaining? The court said they can't be forced to pay the share of the dues that go to support the political activities union. That would violate the First Amendment. After the oral argument on Monday, January 11th, I think there's little doubt as to what the Supreme Court's going to do. Not one of the 5 conservative justices asked a single question that cast any doubt. And I think the court's likely to overrule Abood. And then in California, in 21 other states, there's substantial reduction in revenue for unions and union membership, which will change the political landscape of the country. Third case I'd mention is Evanwell versus Abbott. It comes out of Texas. It was argued Tuesday, December the 8th. What's involved here is, how is districting to be done? In the early 1960s, the court articulated the principle, one person, one vote. For any elected body with districts, all districts must be about the same in population. After leaving the court, Chief Justice Earl Warren said, of all the cases decided in his tenure, he thought the one person, one vote cases were the most important. But now the challengers are arguing in the Supreme Court, districting should be based on eligible voters, not based on population. Let me take Los Angeles, the city I know best, as an example. There's a substantial non-citizen population, both documented and undocumented. There's a substantial population of individuals who are permanently disenfranchised from voting because of felony convictions. If the court says districting is to be on the basis of eligible voters and not population, requiring immediate redistricting in Los Angeles City Council, Los Angeles County Board of Supervisors, the California Assembly, the California State Senate. It will mean a substantial decrease in political power for minority communities and cities, significant increase for suburbs and rural areas. It will dramatically help the Republican Party and hurt the Democratic Party. Fourth area that's before the court this term involves reproductive freedom. There's the first abortion case to come before the court since 2007. The case is Whole Women's Health Center versus Cole. Texas adopted a law that said that any facility where abortions are performed, the doctors have to have admitting privileges at hospitals within 30 miles, and any facility where abortions are performed have to have surgical quality facilities, even if no surgical abortions are performed there, only if it's only medically induced abortions. This would close about 80% of the facilities in Texas where abortions are performed. It would mean in some states, like Mississippi, all facilities where abortions are performed would be closed. How is it determined what's an undue burden on one's right to abortion? Does the state have to prove that these restrictions are necessary to protect women's health? Final example of a blockbuster case in this term had cert granted a week ago Tuesday, January 19th. The case is United States versus Texas. In November 2014, President Obama announced this executive action known as DAPA, Deferred Action for Parents of Americans. It says that if a person has been in the United States since 2010, and as a child who's a citizen or a lawful resident alien, and the parent doesn't have a criminal record, the parent will be able to stay in the United States for at least 3 more years. It doesn't grant citizenship. It doesn't grant permanent resident alien status. It's just deferring deportation. Texas and 25 other states brought a lawsuit against this. Federal District Court in Texas issued a preliminary injunction. The Fifth Circuit affirmed 2-1. The Supreme Court has granted review on 4 questions. Does Texas have standing to bring the suit in federal court? Is it sufficiently injured? Did the Obama administration violate the Administrative Procedures Act by not going through notice and comment rulemaking? Is the executive action so arbitrary and capricious as to violate the Administrative Procedures Act? And finally, the constitutional issue. Did President Obama violate his duty to take care the laws are faithfully executed by granting deferred status to these individuals? The Obama administration says there's about 11 million undocumented people in the United States. Only 400,000 or so are deported a year. They should be able to set enforcement priorities. Texas says that the president violated the Administrative Procedures Act and the Constitution by announcing that these laws would not be enforced. So if that's the immediate past and the present, let me conclude with a couple of minutes about the future. I think the most important issue in the November 2016 presidential election is who is likely to fill 4 vacancies on the Supreme Court. Since 1960, the average retirement age of a Supreme Court justice is 79 years old. In 2017, the year the next president will be inaugurated, there will be 4 justices who are 79 years old or older. Right now, as we speak, Ruth Bader Ginsburg is 82, Antonin Scalia and Anthony Kennedy are each 79, and Stephen Breyer is 77. Especially if it's a two-term president, it seems inevitable that there will be 4 seats on the Supreme Court to be filled. The longest lasting legacy of any presidency is who that individual puts on the Supreme Court. Imagine if it's a Republican president who gets to replace Justices Ginsburg and Breyer, in addition to Justice Scalia and Kennedy. To take a single example, it seems a certainty then that Roe versus Wade will be overruled. Or imagine it's a Democratic president who gets to replace Justice Scalia and Kennedy, as well as Ginsburg and Breyer. Equally much, it seems a certainty that, say, Citizens United or District of Columbia versus Heller about the Second Amendment would be overruled. So I think whether you're Democrat or Republican, liberal or conservative, it is so important that we as lawyers get out the word to people that there is nothing more important in the coming presidential election than who's going to fill those seats on the Supreme Court. Because as I said, we have to remember that what the Supreme Court does truly affects all of us, often the most important, the most intimate aspects of our lives. Thank you.